Get ready, start. During the pendency of the aforesaid interim application seeking condonation of the delay, the respondents filed another application being IA number 1977 of 2011 in IA number 598 of 2011 seeking an order of the trial court to summon the sub-registrar to prove the veracity of the memorandum of understanding and to counter the allegations raised by the appellants herein as to the falsification and fabrication of the memorandum dated 9.4.2010. For completeness of narration, it may be stated that additional IAS Boeing IA number 210 and 211 of 2012 were sought by the respondent seeking certain documents to be brought on record by order dated 21st.2.2012. The trial court dismissed the IA number 598 of 2011 pertaining to the condonation of delay in filing the Section 34 application. The trial court, while dismissing the aforesaid application as indicated above, reasoned as under being aggrieved by the dismissal, respondents preferred 4 civil revision petitions before the High Court of Andhra Pradesh under Article 227 of the Constitution of India, being CRP number 215122462383 and 2458 of 2012 by the impugned order dated 18.6.2012. The High Court remanded the matter to the trial court concerning the applicability of Section 17 of the Limitation Act in an application under Section 34 of the Arbitration Act. On this short ground, I feel that it is just and appropriate to remand the matter back to the learned Chief Judge, City Civil Court, Hyderabad, for considering the above mentioned pleading of the petitioners and pronouncing upon the same with reference to the applicability or otherwise of the provision of Section 17 of the Act. Therefore, without expressing any opinion on these aspects, the learned Chief Judge is directed to reconsider the case only to this limited extent and pass a fresh order after hearing both parties with a period of 2 months from the date of receipt of this order. It is made clear that the orders of the lower court in respect of the other aspects stand confirmed, aggrieved by the remand order passed by the High Court on the applicability of Section 17 of the Limitation Act to the proceedings. The appellants have approached this court in these appeals. Before we delve into any other aspect of this case, it may be important to note that we would have agreed with the High Court wherein a remand may have been required in usual course for considering the applicability of Section 17 of the Limitation Act, as there is an apparent insufficiency of reasons in the trial court order. But In this case, there has been a considerable delay in resolving the dispute. The very purpose of speedy justice delivery mechanism would be frustrated by such delays if the matter is allowed to linger before the courts. We had possibility persuaded the parties several times to come to an amicable settlement and ask the advocates repressing them to use their good offices to refer parties to mediation and avoid decades of litigation. But our efforts were not met with much success in any event. Stop.